Greetings, Dirtlings. Well, this is an excerpt, a random excerpt actually, from the middle of my forthcoming true story, The Banker's Secret. Um, and I just picked a random selection, because of course I think it's good since but how can I really trust my own judgment since I wrote it? Obviously, there's an implicit bias. It's not just an overt bias that I'm consciously aware of, but, if you're really vigilant about such things, hopefully the product will be better in the end. So yeah, this is The Banker's Secret. There really is one. Actually, there are two in here. And I just picked a random excerpt. I don't think it's the best part of the book, but again, although my opinion is biased, I don't know, it seems decent. True, everything in here is true. Maybe told in an exaggerated fashion, but only for effect. Everyone sort of eventually found out that there was and is no such thing as a land patent. That's just a random sentence. Sounds boring, but it's not actually. This stuff it'll light you up. All right, well, now random pages like interspersed randomly with each other without regard to sequence. Probably not going to present my story in the best light, but actually you could grab any portion of it. So whatever, let's see how we roll here. Yeah, man. All right. At that time, in early 2011, Fort Myers was running one of the most infamous rocket dockets in the state, if not in the entire country. In my first few courtroom appearances there, I observed that court was conducted in the following most suspicious manner. Case name called by bailiff. Plaintiff's lawyer is already standing right up in front of the bench. Defense counsel, if there is one, gets up from the gallery, opens the little wooden gate separating the gallery from the area occupied by the attorneys, sheriff's deputies, the judge, and the judge's staff, walks up to the front, and stands next to the bank's lawyer. Suddenly, a bevy of whispering would ensue between the lawyers and the judge. After a few moments, the defense counsel would walk back through the gate and into the gallery, at which time his clients would anxiously approach and begin asking him what had happened. The lawyer would typically tell the clients to come outside with him into the hallway so that he could explain. Alternatively, where the homeowners were present without counsel, the case name would be called by the bailiff. The homeowners would rise from their seats and approach the little wooden gate, only to be met there by three aggressive deputies and informed that they could not go past the gate. Inevitably, there would again be whispering between the judge and the bank's lawyer. Next thing, the bailiff or one of the deputies would tell the homeowners to wait him back for your paperwork. Locally famous movie producer, director Billy Corben heard about the rocket docket in Fort Myers and called me, through an uproariously funny, glamorous, obscene, and hyperactive assistant, to ask whether I had any cases in Fort Myers and whether I had any clients that might be willing to challenge the practice of keeping the homeowners in the gallery so as to prevent them from understanding what is happening in their cases. I said, hell yes, and immediately called a diminutive German immigrant house painter client of mine and explained the situation. He excitedly agreed to participate. Corben obtained advance permission from the 20th Judicial Circuit, and at the appointed day and time, while being filmed, my client and I boldly strode toward that damnable little gate. I tossed it haughtily aside, and my client and I stepped over the line shoulder to shoulder. Whereupon the triploid of deputoids parted like the Red Sea and graciously extended their arms as if to guide us forward on toward the bench. I was momentarily speechless. Needless to say, that wasn't exactly the clip that Shock Jock and Coterie were anticipating. Later, policy changed so that all foreclosure trials in Fort Myers were heard by a magistrate, one whose professional profile, if truthful, would include non-native speaker of English. I have a transcript of a hearing before this lady occurring back in 2015. I kid you not, here is the very first line. The court. Have the party had the opportunity to talk? At the conclusion of the trial, after I completely exposed the fraudulent nature of the evidence that was presented, and quite frankly blew the case out of the water, her wisdom announced her decision on the record. The court, well, we are granting the final judgment of foreclosure for the following reason. I consider that the plaintiff has met the burden of proof for the foreclosure action. I consider that the demand letter is sufficient to please the defendant notice of the foreclosure action. The note, The original note that was delivered to take to the court is bearing a blank endorsement. And even taking the assumption of the defendants that the copy of the note that was attached to the complaint has no endorsement, and the original note that was submitted today is containing a blank endorsement, when you look, who is the lender? The lender is HSBC Mortgage Corporation. Who is the plaintiff? The plaintiff is HSBC Mortgage Bank. Actually, HSBC Bank USA NA. And the witness testified that both entities are the same. The same bank uses multiple names? Shocker. So basically, we have that the lender is the same of, it's the same person or the same entity of the plaintiff. So basically, no endorsement is necessary. Why then is there an endorsement and an assignment from one to the other? The magistrate confused herself all on her own. No need for MERS. With the outrageous practices in state court, I looked to federal court as the answer. I thought I had a good opportunity to strike a blow for the regular folks with the class action, Figueroa versus Stern and MERS, which I planned to and did file in the United States District Court in and for the Southern District of Florida, which is part of our federal court system here in the United States. Regrettably, in the end, I would find the same outrageous bias in the federal courts as homeowner advocates like myself, Josh Blyle, and Matt Widener experienced on a daily basis in the state courts. There's only one court left to which I can resort. What court is that, you ask? The Court of Public Opinion. What's your opinion so far? Chapter 14. In August, September, and October of 2010, the class action was moving quickly. By then, it was myself versus 20 big-name law firms from all over the United States. The judge was Cecilia Altanaga. She was super smart and exceptionally mean. She was on the case like stink on shit. She ruled immediately on every motion that was filed. To be precise, the action was filed on July 26, 2010, almost a decade ago. By October 14, same year, she had entered 21 separate orders. Even though her early rulings smacked of pro-bank bias, she managed to toe the line in such a way that she did not give me a good faith basis to file a motion to disqualify her. Plus, the way the press was reporting revelations which were consistent with, and which strongly supported the factual allegations in our complaint, I could not imagine how she could justify rejecting our claims as fantastical or without basis. After all, both the law and the facts were 99% plus in our favor. Power to the 99%! After October 14th, I should have known the game was up. I should have filed a motion to recuse, but I still held out a scintilla of hope, an arguably sexist one, that she had been in a bad mood under a bad moon when she wrote the following order. All right, guys, that's an excerpt of The Banker's Secret. Get it and pass it on, baby. The opposite of the virus. Actually, my book is the antidote to the MERS virus, which is largely what the book deals with. Bank of America sucks.